We thank you so much for watching Law School Med Easy at Law School Med Easy 256. Today we want to discuss the law of torts, and we want to discuss the history of negligence and also the elements of negligence. So in this case, I'm going to look at two cases, two distinctive cases. The case of Heaven versus Pender, and then the case of Donoghue versus Stevenson. And these are the cases that established the principles of negligence that we have today. However, in the various cases afterwards, the principles have been changing, but let us begin with the history of negligence. Now, to begin with, before 1932, for someone to succeed in the tort of negligence, you had to have had a contractual capacity. That if you did not have a contractual capacity, then you could not succeed in the tort of negligence. What does this mean? This means that if you wanted to go to court, you had to go to court when you were in a contract. That Walter and Fiona, Walter and Isma, we have a contract. If I hire Isma to do something for me, that means me and Isma, we have a contract. So if anything goes wrong, then Isma can sue on the contract and they will succeed. The requirement for the tort of negligence before 1932 was that you must have a contractual capacity. Where you didn't have a contractual capacity, you could not succeed in the tort of negligence. Let's take an example. We look at the case of Pender, Heaven versus Pender. Now, there was the owners of the dock. They hired Pender, and them were in a contract. And Pender gave them a stage to help them to paint their dock, ship dock. Now, the owners of the dock, remember, they have a contract between Pender and them. Then Pender just gave them a stage so that they would use to improve and paint their ship dock. Now, the contract, remember, is between Pender and the ship owners. Now, the ship owners hired Heaven to come and paint. Heaven was the painter. So they hired Heaven to come and paint. So, but Pender's stage, they were using ropes which had been burnt. So when Heaven used them, he fell. And now Heaven took Pender to court that he hired the other people's stage which was not in the right conditions. So the issue at court in Heaven versus Pender was whether Pender owed a duty of care to Heaven. So in that case, court ruled that Pender did not owe a duty to Heaven, and therefore it never succeeded. But Lord Brett M.R., Master of Rolls, in his judgment, this is a very distinctive case. I want us to pay close attention. Court held that Pender did not owe a duty of care to Heaven, and therefore Heaven never succeeded. But the minority judgment of Lord Brett M.R., Master of Rolls, he said that where you invite me to your area to offer a service, you have a duty of care on me. This was a minority decision. So Lord Brett, Master of Rolls, he established that a duty of care should have existed in that circumstance. But because the rule was, you must have had a contract with me for you to succeed, and that is why the ratio decidendi in that case was that Pender did not have a contract with heaven, and therefore heavens could not succeed. The ratio decidendi was solely based on contractual obligation. But we have a minority judgment introducing the word duty of care. Okay. Now, in 1932, we get another case, the famous case of Donoghue versus Stevenson, where Donoghue's friend bought a ginger beer from a retailer, and then Donoghue took the beer and got complications. But remember, Mrs. Donoghue was not in contract with the retailer and the manufacturer. But Mrs. Donoghue went to court suing the manufacturer. By look of things, this would not succeed. Remember, we said for you to succeed, you had to have a duty of care. You had to have a contractual capacity or obligation. So in this case, Mrs. Donoghue has no contractual obligation with Stevenson, the manufacturer. But the case succeeded. Why? This is what your lecturers want you to pick from the case of Donoghue versus Stevenson. Your lecturers want you to stress out to the point that Mrs. Donoghue was not in contract with Stevenson. However, Lord Atkinson, in the case of Donoghue versus Stevenson, stressed that the principle of neighborhood, the neighborhood principle. He posed the question and said, in the principle that love your neighbor as you love yourself, what is that in law? And he explained that in law, your neighbor is someone who can be affected by your actions, by the things you do. Therefore, Lord Atkinson held the manufacturer liable that his negligence when he packed the beer and there was a snail in that beer, that his actions as the manufacturer, his actions hurt the neighbor being the people who are going to consume that beer. And therefore, Lord Atkinson established the element of duty of care, that for negligence to occur, there must be a duty of care. And that duty of care, must be bleached. So we are having the first element of negligence as being existence of a duty of care. And element number 2, that duty of care must have been breached. And number 3, it must have resulted into damages. So Lord Atkinson established those principles in the case of Donoghue versus Stevenson. And those are the elements that we follow up to date. For negligence to occur, there must be 3 elements. Number 1, there must be a duty of care. There that duty of care must have been breached, and the breach of duty of care must have caused the damage. And that is the flaw. So, in giving his judgment, Lord Atkins, he based on the minority judgment of Lord Brett in Heaven versus Pender. That is where he got his judgment. His ratio decidendi relied on the judgment of Lord Brett under Heaven and Pender. So, if you want to start an action against anyone, okay, in terms of negligence, the contractual obligation is now useless, because now we have established the elements of negligence. So all you have to look at the relationship between these people. Did there exist a duty of care? Did one party have a duty of care? If there was existence of a duty of care, was that duty of care breached? Was that duty of care breached? If that duty of care was breached, were there damages caused by the breach of duty of care? So when you breach the duty of care, it must be leading you to damages. By so doing, you have the full elements of negligence. Now, in subsequent videos, I'm going to discuss now the duty of care and the breach of duty attaching cases in one of the next episodes on negligence. So that was the history of negligence. That before 1930, for you to succeed in the tort of negligence, you had to have a contractual obligation. And after that, the neighborhood principle was established by Lord Atkins in the case of Donoghue versus Stevenson, and three elements of negligence were established, and that is duty of care, breach of duty of care, and then damages. And then from there, we shall now discuss the elements of causation and also the elements of causation and oh my god, of course, causation, proximity, and all those other things around the negligence, the elements of negligence. So we thank you so much for watching Law School Made Easy. At also remoteness, we shall discuss causation and remoteness. We see what do we mean by causation, what do we mean by remoteness of damages, and all those things. So we thank you so much for watching Law School Made Easy. At Law School Made Easy 256, subscribe, share, and keep liking our videos. Until next time, thank you, cheers.